I have an interesting point. A friend of mine was selling a building that was in her family for 80 years in Brooklyn. During the title search, it turned out that her grandfather had 2 children that nobody knew about. And then when they sold the building for $5 million, those 2 children came forward and were entitled to money. So what has happened in something like that?
Yeah, well, that's when title insurance would kick in, at least for the buyer who bought that. If they then came and made a claim, that would be something that, the title insurance company would then defend, in that litigation. But that's kind of an interesting, issue there, because I'm just wondering who was entitled. I guess it was the grandfather, right? And then I imagine the estate did an administration proceeding. But if they didn't know about these heirs, you're taking title out of the administrator. It's gone through the surrogates proceeding. You think that everything is fine, and that there's no issues, and the administrator has the right to transfer it or do whatever, and then transfer the the funds for the estate and to the different heirs. So that's kind of interesting too. And typically in that situation, if it was an administration and there's consideration on the deed, typically that would follow the money.